Next case is People versus Wilder. No relationship, right?
No relation.
Please wait just a moment. Please proceed.
Mr. Chief Justice, and may it please the Court, Adrienne Young from the State Appellate Defender Office. I'm here today on behalf of Mr. Wilder. I understand it's my responsibility to keep track of my own time. I'm going to do my best to reserve my final 2 minutes for rebuttal. Mr. Wilder is entitled to a new trial because the admission of Mr. Wilder's priors was more probably than not outcome determinative. As this Court well knows, when the admitted prior conviction is similar to the pending charges, the risk of unfair prejudice is especially obvious. But here in this case, that's particularly true. It was a very close case. There were 2 days of deliberation, and the jurors required an Allen instruction because initially they couldn't reach a verdict. True, there was the testimony of Officers Foltz and Shaw, but there were no fingerprints, no footage, an incomplete and inaccurate firearms report, and several unaccounted for black males at the scene. Additional circumstances added to the confusion of the admission of Mr. Wilder's priors. One is that they came in response to the question, "You've been married to him for 9 years and you don't know of him to carry guns?" In essence, they came in on a collateral matter. Notably, in analyzing, the trial court and Court of Appeals at times attributed this question to defense counsel. Secondly, the priors came in without a trial court instruction. And finally, the priors were revisited by the prosecutor in her closing when she stated, "Defendant had some contact with weapons in the past." And for all these reasons, this evidence actually should have been excluded under 403, but notably, the trial court didn't perform a 403 analysis and also, as stated earlier, operated under a misunderstanding of the facts. For those reasons, the trial court abused their discretion. In essence here, the jurors were free to use, and likely did use, Mr. Wilder's priors for their impermissible purpose. To borrow this court's language in Denson, the introduction of the priors essentially rendered it inconsequential whether Mr. Wilder actually did possess a weapon on May 16, 2014, because the jurors could conclude if he did it before, he did it again. And for those reasons, he's entitled to a new trial.
Is it only 403 or is it 404B that we should be thinking about as well?
Well, as this court knows, 403 analysis is part of, under Vanderbilt, the 404 analysis. But I don't believe that
there's a separate question of whether impeachment is a proper purpose under 404B, which I think is a very odd thing to say, but the Court of Appeals did say it here. Apparently the prosecution thought it was odd as well, because I don't think they're urging us using that rationale to find for the people in this case. But I'm just curious if you have any comments on that.
So you're correct, the Court of Appeals and the prosecutor said this actually falls outside of 404B because Mrs. Wilder, A, wasn't a character witness, and B, which is different than what the trial court said. And I agree, she was a fact witness.
I thought the Court of Appeals said impeachment was a proper purpose under 404B. Did I read that wrong?
I read them as saying 609 was inapplicable, and that this was that this case. Yeah, I didn't see them.
Page 4 of the slip opinion.
So 404B when it's relevant to a non-character purpose. So essentially, impeachment's always relevant is the argument presented by the Court of Appeals.
Yeah.
And
there's rules that govern impeachment, right? 608 and 609.
Right, and the Court of Appeals said that neither of those were applicable because 608 actually involves, well, as this Court knows, impeaching based on actions by a witness. Mr. Wilder wasn't a witness, and it's not 609 because they're not truth or veracity priors. So if this falls in under 404 as a non-character purpose, if impeachment is one of those, you still have to perform the 403 analysis before we get to that. And I think that that this evidence was substantially, that the unfair prejudice substantially outweighs the probative value for many of the reasons that I acknowledged in my opening. It was a closed case. It's priors that are identical to the charges which Mr. Wilder faced. And notably, because the trial court failed to even perform a 403 analysis, they were operating under a complete misunderstanding of the law and thus abused their discretion.
Ms. Young, in response to defense counsel's questioning on direct examination, we learned, among other things, that the defendant is left-handed, that he did or did not own corduroy pants, and that Mrs. Wilder had known him for about 16 years. What, in summary, joins that information together? In other words, what was your best succinct characterization of what it was that the defense counsel was addressing in the course of eliciting those answers?
I think what you're getting at, Chief Justice Markman, is whether she was a character witness or a fact witness. My best characterization...
No, I'm asking what I hope I'm asking, and that is, what was the general, how would you generally summarize what it was that she was attempting to elicit from Mrs. Wilder? What was the subject of his analysis, of his examination?
I believe the trial attorney was attempting to respond, at least in part, if not in total, to the testimony from the officers. So, for example, the officers testified on which side of his hip they allegedly saw a weapon, which hand they saw him place it in the trunk, and so I think she was attempting to respond and contradict some of the testimony from the officers in questioning Mrs. Wilder.
I guess I would have characterized things a little bit differently and asked whether you might do that too. Wasn't the defense counsel attempting to elicit something concerning the relationship between Mrs. Wilder and Mr. Wilder?
I think defense counsel's direct examination was attempting to establish that Mr. Wilder left on the day in question without possessing a weapon. But your additional facts that you provided go beyond that. And I think the additional facts that go beyond that, the corduroy pants, the left-handedness or right-handedness, all of that responds directly to testimony from Officers Shaw and Fultz. So I think that was an attempt to call that into question.
So is there nothing that joined or that rendered common the 3 points that I just raised in my question? The 16 years of a relationship, the knowledge of left-handedness or right-handedness, and the knowledge, what was it, concerning the kind of shirt that he did or did not wear.
I think one common thread is, I believe it's 602 that requires a witness to have a particular knowledge base in order to testify on a matter when they're non-expert. And perhaps her relationship with Mr. Wilder establishes that she should at least know his left or right-handedness or what pants he wore.
Just to qualify her as an appropriate witness.
As an appropriate fact witness, yeah. As an appropriate, I mean, 602 applies to all witnesses, so that's the common thread I saw. So first I want to address something that I said in my opening. I said that this was a collateral matter. And I think what's important when analyzing whether the matter is collateral is that we look at the question that was asked. Put differently, it's not enough to say that impeachment is never collateral. We have to look at the questions that were posed by the prosecutor on cross-examination. And in particular, the question, you've been married to him for 9 years and you don't know of him to carry guns? This is essentially asking about Mr. Wilder's propensity to carry weapons, which is not relevant to anything that gets at Mr. Wilder's guilt or innocence in this particular case.
Before you, just to lay the groundwork,
Sure.
The cross-examination did not contradict anything that was said on the direct exam. Is that your position?
That is our position, Your Honor. Put differently, we
So
don't
now-
find that defense counsel opened the door.
Right, I understand. So you're into whether it's collateral. I mean, it's possible that the prosecutor on cross-exam, the court would allow the prosecutor to go a little bit beyond direct exam, right?
Sure, and I think, I think absolutely. There's no, it has to mirror direct rule, for example. But to go this far, to make the scope the entire length of
Your
Mr.
point
Wilder's.
is it's improper for the prosecutor to ask about the defendant's criminal tendencies or propensity, to use your word, purely as a way to try to admit otherwise inadmissible evidence.
That's
It's sort of a workaround all these other rules that are in place to protect the defendant's rights.
absolutely, and I'd submit, Justice Viviano, that language that you're using essentially fits cleanly within what makes an issue collateral. And the fact that they wouldn't be able to present it otherwise, and the fact that it's not directly getting at Mr. Wilder's guilt or innocence in this case. And so if the issue is collateral, Justice Markman's introduction to this court about rules of law and bigger picture things, I think really comes into play right here, because this court essentially has two options. So say this is collateral. Well, then the next step is, was Mr. Wilder impeached with extrinsic evidence on a collateral matter? I'd submit to this court that the answer is yes. This court might then respond, well, it's cross-examination. By definition, that's not collateral. But here, we have what the Third and Fifth Federal Circuits have defined as sort of a backdoor way of getting around that extrinsic evidence rule. You're inserting the content of what would otherwise be extrinsic. Here, in the Third and Fifth Circuit cases, you're quoting a third party. Here, you're inserting content from a rap sheet or his priors into the questions. That makes the questions themselves extrinsic evidence. And I would ask the court to adopt that rule. In the alternative, if this court finds, well, no, it's not extrinsic, we're looking at Stanaway. It's something that got to the central issue of the case. And as Justice Markman pointed out, Mrs. Wilder's testimony involved a great deal more information than just whether Mr. Wilder had committed these priors.
Is it relevant in any way that the prosecutor did not, in fact, ask Mrs. Wilder if defendant carried weapons, but merely whether she knew of him to carry weapons?
I think...
And she was presumably an expert on him, given the questions that we saw coming from the defense counsel.
I think the framing of those questions, do you know of him to carry weapons? Next was, do you know of him to carry guns? If there's any question as to how broad and what she's getting at in those arguments, the third question really resolves that issue. You've been married to him for 9 years and you don't know of him to carry guns? The prosecutor has quite clearly taken us out of the frame of present tense, the same tense that the defense attorney used on direct, and taken us into his history. And that's where it becomes a collateral issue. So though those questions, one could say, taking it out of context, perhaps they're not as broad as you say they are, counsel, but in fact they are, and that was cleared up by clarifying, oh, the frame of reference is the 9 years of your marriage. And so the second option with this court, if this court finds this clearly fits into Stanaway, it gets at a central issue, which I don't agree with, and it's Mrs. Wilder's testimony was relevant for more than just this cross-examination material, then I'd ask this court to say, because it's not clear from Stanaway and Kilbourne, that 403 should still apply in that circumstance. So let's say you check both those boxes. It shouldn't be that the impeachment comes in right away. You should still, the court should still have that gatekeeping function on evidentiary matters, particularly those that this court has recognized and the evidence rules are aimed to protect against the use of priors in this manner. And so barring any other questions at this time, I'm just going to save the rest of my time for rebuttal.
Well, you've also you've just focused a few moments ago upon the idea that defense counsel's questioning was in the present, and that somehow the prosecutor transformed that into a more retrospective look at things. My analysis or my review of that questioning by defense counsel was that there were a number of occasions in which defense counsel discuss separations from the defendant, whether the defendant had other residences, and doesn't that kind of put things in the past?
No, I think those are all present tense questions. And I want to clarify that a lot of the did you have alternative residences were actually also on cross-examination. Those were questions asked by the prosecutor leading up to this line of questioning. Don't you know about his hideout on Pennsylvania Street? Isn't this grandma's house? Do you know what he keeps at grandma's house? Those were cross-examination. Here, on direct, the trial attorney asks, when you see your husband leave the house, do you see him with a gun? Then asked, to your knowledge,
on the day in question.
What's that?
On the day in question, right?
What's that?
On the day in question.
Yes, that's exactly my point. The time
Obviously
frame
very
is the
specific
present.
to the offense. The others they're not quite as specific time-wise, but they're very specific questions. Does he own a gun?
Right.
Right now, does he own a gun? Yes or no? That doesn't open the door to his prior convictions.
That's exactly our argument, Justice Viviano. And I'll note to the court that should there be disagreement on that issue as to whether the breadth of her questions and whether she opened the door, we did in our application raise this in the alternative as ineffective assistance of counsel. If trial counsel, in the mind of members of this court, somehow transform this to a broader issue, we do raise that.
That's by asking the questions? Were those questions improper somehow?
No, I believe not. That's why we just say in the alternative, if this court should find that they are, in the alternative, it's ineffective assistance of counsel.
There were mistakes made here, but not by defense counsel.
Should defense counsel have objected when the question was, you've been with him for 9 years and you don't know of him to carry guns?
I think she absolutely was in the realm of, she could, yes. The short answer is yes, she could have and should have objected.
Wasn't there a whole argument before this testimony was presented about whether, was there a sidebar or out of the jury's presence?
So I'll address both of those. So to Justice Zara's point, could she objected to the first question? Do you know of him to carry guns? Yes, that's collateral. You could object right away. But perhaps she relied on the collateral evidence, can't impeach through extrinsic. You have to deal with the response that you get. So perhaps she relied on that. But then almost immediately after, as Justice Viviano points out, there was this sidebar in which she raised the fact that this was collateral. She said it wasn't relevant. She said, so she effectively did voice what would have been her objection if she had done it.
She could have been a little bit more nimble.
Right.
Was the 403 argument raised at that time in the sidebar?
Not at the sidebar. It was more 401, 402. She focused on relevance. In her mistrial, she did establish that this was unfairly prejudicial.
But it could have been raised before the trial court ruled as to whether she was going to allow it. Yes, that's true as well. And again, I just recognize that should this court find fault in the way that defense attorney handled this, we did in our application raise IAC in the alternative.
So I'm just thinking it through. So you don't object to the question. It's your client. If the client says, I've known him to carry guns in the past, but not at this time, nothing occurs with that, right? You can't bring in anything. The whole thing goes away.
Right.
So I can't say that was error not to object, right?
I agree.
But once you get the answer that you didn't expect, can't you impeach on that?
No, because it's a collateral. Well, let me clarify. You are stuck with the answers that you get on a collateral matter. That's the established rule. You cannot impeach them with extrinsic evidence, which gets to my earlier point. Well, is the follow-up line of questioning about his priors, is that extrinsic evidence? And I would submit that it is. And recognizing that my time is up, I'd just like to conclude by saying that essentially the jurors are left to conclude that if Mr. Wilder did this before, he did it again. That's particularly important in a case as close as this one. The prosecutor raised a collateral issue on
Your time is up, Ms. Young. Your time is up.
So I'd ask for a new trial for Mr. Wilder.
Do you want to wrap it up briefly?
Thank you. What's that?
If you want to wrap it up very briefly, that would be fine.
So I'd ask this court to award Mr. Wilder a new trial based on either the failure to perform 403 or that the issue was collateral and impeached by extrinsic evidence. Thank you very much.
Thank you, counsel. Mr. Williams?
Good morning. Jason Williams, Assistant Prosecuting Attorney from Wayne County for the people of the state of Michigan. The question in this case is whether the trial court abused its discretion in permitting the prosecutor to impeach defendant's wife with her knowledge of defendant's prior weapons convictions. Our belief is that the Court of Appeals correctly deferred to the trial court on that discretionary question and correctly concluded that the trial court had not abused its discretion. Whether a witness falsely answered a question during her testimony is always relevant to her credibility. And when defendant's wife denied at trial knowing the defendant carried guns, her knowledge of defendant's weapons convictions became relevant, as a jury could find that she had not been truthful during her testimony and consider that factor in evaluating her credibility. Trial court here properly exercised its discretion to permit that questioning. The Court of Appeals correctly upheld that decision. We therefore ask that the court deny leave to appeal. I would waive the remainder of my free fire zone.
Were those questions appropriate?
I believe they are appropriate in this case because of the manner of which counsel did question the witness. And I think as Justice Markman pointed out and I think it goes beyond particularly the particular questions asked, and it's really an instance where counsel, number one, she asked a second question.
The questions didn't contradict anything that was stated in direct.
I think defense counsel, in addition to asking particular questions and emphasizing the amount of time that this witness or the wife had known the defendant, clearly was trying to get the jury to draw an inference.
You think it's unusual when in trial somebody emphasizes the length of the relationship between the witness and one of the participants in the case?
It's not unusual, and in this case, I think it was an effort on defense counsel to ask particular questions, but also get the jury to draw an inference. And I think the inference was, when you read the questions in series, as well as the other testimony, was to indicate that this defendant doesn't have a connection to guns. And we can explore that.
Can you point me to any case from any jurisdiction that supports your argument here today?
These are general principles and fact-specific applications of MRE 402.
Well, there are general principles. They're stated in the rules of evidence. This could be viewed as a routing around those rules. 404B goes to a lot of trouble to specify when other acts of evidence can and can't come in against the defendant. Isn't this just a neat way of getting around that rule?
Evidence that may be inadmissible for one purpose can be admissible for another. And in this case, the witness was impeached with her knowledge, which directly refuted an answer that she had given.
I couldn't find any cases anywhere where somebody tried to do this through a witness. Typically, the prosecutor tries to do it through the defendant's own testimony, and then it's universally rejected by courts. But this is so far out of the stratosphere that I couldn't even find any case, anything like it. And I guess my question is, does your office ever consider conceding one argument on one point and coming in and just arguing harmlessness?
We do in certain instances, and we do in certain instances argue harmless error and concede other issues. I think the Court of Appeals correctly analyzed this case as it's really a
The Court of Appeals said impeachment was a proper purpose under 404B. Is that your position?
Our position is that 404B doesn't govern non-substantive uses of the evidence.
So even you don't support what the Court of Appeals said, right?
Our argument is that I think it's clear from this Court's cases, this Court's decisions in People v. Taylor and People v. Lair, that which the Court did have instances of the use of other acts evidence in the impeachment realm, and did not view it as a 404B evidence issue at all.
So you think the Court of Appeals was wrong?
I think they were wrong in their analysis, correct in the outcome.
Mr. Williams, you also said that they were correct, the Court of Appeals was correct to defer to the trial court, and I'm confused about that. The trial court said, I don't know when the door was opened, whether it was on direct or cross. Do you think it matters? If the defense attorney had asked the witness, have you ever known him ever to carry a gun, don't you think you'd have a stronger argument today?
I would have a stronger argument.
So
I would concede that, but I don't think that it necessarily means that it's an abuse of discretion under the facts of this case.
So you think it matters when the, quote, door was opened?
It is a factor that a court can consider in determining whether to admit the evidence or not.
So when you said the Court of Appeals was correct to defer to the trial court, and the trial court said, I have no idea when it was opened, can you explain what you meant by that?
The trial court here, and again, I think as Justice Wilder had pointed out, was faced with just simply a relevance objection and not a 403 issue. I think opening the door is probably more appropriate to consider under a 403 analysis. But I don't think by any means that particular misunderstanding would indicate that this was an abuse of discretion under these circumstances.
Do you think a juror could have reasonably interpreted the witness's response that she did not know of him to carry guns as possibly suggesting that she never knew of the defendant to carry weapons?
Oh, I think certainly a jury would understand that. I think that's the reasonable.
Will you develop that just a little bit and tell me why it's irrelevant if, in fact, that broader understanding of his response, although maybe not the technically correct understanding of that response, nonetheless is sufficient to trigger the kind of cross-examination that was engaged in here?
Because I think I think when the court's viewing evidence and viewing answers that are given, the court's jurors don't necessarily parse the particular words used. They draw what it may be more of a common understanding of what the witness is saying and what the message is being given by the witness in answering those questions. I think that's is what counsel in many ways was going for here in the direct examination. And it's appropriate for a prosecutor on cross-examination. We have Michigan has adopted more of a broad view of cross-examination to explore those kind of inferences through questioning of the witness.
Did you agree that collateral evidence is inappropriate for impeachment purposes?
I don't believe the collateral, whether an issue is collateral or not, is a question that comes into play and is addressed by courts when extrinsic evidence is used. And extrinsic evidence is when you call another witness to the stand, or in this case, extrinsic evidence would have been if we had admitted the convictions.
If the prosecutor asked, are you aware he was convicted in 2007, and the answer was no, the prosecutor would not be able to then produce the actual conviction. That would be extrinsic evidence.
That would be extrinsic evidence. And
You're stuck with that answer.
We would be stuck with that answer.
So why isn't the prosecutor stuck with the answer, you've been with him 9 years and you don't know of him to carry guns?
Because whether an issue is collateral or not does not affect whether you can continue to probe the witness on the stand with questions. And I think the McCormick Treatise makes that clear, is generally subject to the court's discretion under 403, you can continue to ask questions of the witness. You can phrase the questions in a different way. And it's all designed to explore and develop whether the witnesses and really challenge their testimony, develop whether they are being truthful or not.
So if I understand your position, then it's when you go outside of the question and answer realm and you seek to have extraneous evidence come in to prove your point, that's collateral evidence that should not be permitted in impeachment.
That's true.
And this is all to the discretion of the trial judge, and there's a lot more discretion when there's question and answer as opposed to extrinsic evidence.
That is true. And I think it's also, a trial judge has an opportunity also, and the judge here had the opportunity to observe the witness when she was testifying. You can pick up nonverbal cues as well as the answers that they're giving to get an understanding of really what the message is trying to be conveyed by that witness.
Should the trial court unilaterally preclude a question from being asked on the basis of 403?
A court can interject if the court views the evidence and not wait for counsel to object.
Is it error for the trial court not to intervene?
No, I don't believe so. And I think it's telling in this case that counsel did not object to the initial questions.
Isn't it possible that asking those questions puts the defense counsel in a difficult position? Because if they object to those questions in front of the jury, it appears to the jury that they won't like the answer to the question. Isn't that sort of the beginning of the problems when prosecutors do this kind of stuff?
That tactical decision is present anytime an attorney raises an objection during trial.
But here
Not
we're starting down the
specifically
road to inadmissible evidence, right? You would agree that the reason we go to all this trouble with 404B and propensity evidence is because everybody recognizes exactly how prejudicial and dangerous it is for jurors to, instead of judging the defendant based on the evidence in the case before them, to judge the defendant based on past acts, right? So you would at least agree that there needs to be some type of heightened scrutiny, or do you think that it's just casually allowed in this circumstance?
404B precludes the evidence for one particular purpose, and that's propensity. It's a rule of inclusion rather than exclusion.
I don't know
For
that.
all other purposes, it can come in, and this
So
is
what's the
one
purpose
permissible
here?
purpose.
So you're back to impeachment?
And the impeachment was the witness's knowledge of those convictions because it does directly contradict
So now
her
you agree with the
testimony.
Court of Appeals. Impeachment is a proper purpose under 404B.
What I'm saying is that under this court's case law and under Taylor and Layer, where it doesn't view this as a 404B issue at all, whether you can say impeachment is a proper purpose under 404B, or whether the court would conclude that this is outside of 404B altogether, you get to the same result.
There was no special limiting instruction after this, was there?
No, counsel didn't ask for one, and there's no obligation on the court to give one in the absence of a request for counsel. But I would add that
Is there
contrary to what
standard impeachment instruction that's given?
there's standard instructions that are given about that the answers are given. There wasn't a particular instruction focused on this piece of evidence. I'd add that although counsel's made an issue of our prosecutor's closing argument, I think if you read the argument in its entirety and look at the words in context, the prosecutor here argued the evidence for the purposes that it was used, which is that this contradicted her testimony. It indicated that she lied during her initial testimony, and the jury should consider that in evaluating her entire testimony.
Do you think there's no danger at all that they may have convicted this defendant because they thought he was a bad person who convicted 2 prior crimes of the exact same nature of the crime at issue before the jury? You have no concern about that at all?
Anytime a conviction is referenced, there's always the possibility that the jury might consider it for other purposes, but I think we
That's
look
why
at
under 404B.
we look at in making those determinations.
That's why if it comes in under 404B, an instruction is given to the jury not to consider it for
an instruction is
improper
given
purpose.
to the jury on request, and there's no obligation under 404B to give an instruction when it's not requested by counsel. In this case, there was no instruction requested. And I think that the jury, in hearing the evidence as it was presented, and is also in hearing the prosecutor's argument where she argued it for the purpose of which it was used during trial, would understand that this went to her knowledge as it bore on her credibility and her answers to the questions, rather than whether a defendant may have had a prior conviction in the past. The jurors are also instructed at the beginning of their instruction that the defendant's on trial for the crime that occurred here, this crime, not necessarily something else, some other crime.
Mr. Williams?
Yes.
I'm still trying to understand precisely what your argument is concerning the connective tissue or the relationship between the defense counsel's questioning of Mrs. Wilder and the prosecutor's questioning. At one earlier juncture, you seem to agree with my suggestion that the potential confusion in her answers to the defense counsel's question were one source of that connective tissue and relationship. I thought, though, that you had also suggested in your brief that there was defendant's emphasis upon how well Mrs. Wilder knew her husband, and it was that kind of joined these two lines of questioning together. What precisely is the connective relationship? Again?
Well, I think that both those factors together, they can't be considered in isolation. The jury's, on hearing all the answers to all the questions, is, I think, considers it in a bundle. And I think the counsel here, both in getting into the relationship between the defendant, whereas you would expect the wife would know about his connection with guns, and the particular questions asked, including whether she knew him to own a gun, which I think is broader than what you've necessarily seen with your own two eyes.
So again, the prosecutor was entitled, in your view, to transform what at least, literally was a question focused upon some relatively contemporaneous episode into a broader question focusing upon some retrospective history. How, again, was that allowed to take place?
Because I think the counsel, when you read all the answers together, the witness's testimony on direct examination entirety, is that counsel's, in the manner in which the questions are asked, and the emphasis placed on the relationship between the witness and the defendant, is trying to get the jury to draw an inference. I think that inference from that entire testimony was the defendant isn't involved in guns. And I think we can explore that on cross-examination to counter the inference through questioning. And again, the initial question asked of the witness, the one that led to the impeachment, was not objected to.
Okay. Thank you, counsel. Thank you. Case is submitted.